Good morning. Okay, let's get started in the interest of everyone's time. Good morning, everybody. Thank you for joining us this morning. We are very excited to have a very exciting presenter and topic this morning. We know that you're often faced, well, I should say one of our biggest competitors, let's say in the home care market, is the gray market, what we call the private market, where clients are going and hiring caregivers privately, not through an agency. And since we see this as being, one of our biggest competitors, we feel like we need to really educate our team about what are some of those risks, so that when you're speaking with families and when you're speaking with potential clients, that you're able to sort of address some of the legal risks of hiring caregivers privately. So we asked one of our attorneys, Howard Davis, to join us this morning and present to you guys about some of these risks. Just so you guys know, Howard works for Meister, Seelig & Fines. They've represented caring people in a number of legal employment issues. And we're very excited that Howard, you're able to join us this morning. Everyone should be able to see Howard's screen at this point, risks of hiring private. And what else I'm going to do is I'm actually going to mute everybody so we don't get feedback. But you should all have a chat box in your GoToMeeting. So please do share questions in your chat box. At the end of the presentation, if we have time, we will definitely take questions. And Howard's contact information is on every slide, which I will email around after the presentation, so you guys can have that contact information and can reach out to Howard. So I'm going to mute everybody. And
I guess. Okay, I believe I'm no longer muted.
Right.
So thank you, Adina, for that wonderful introduction. I appreciate it. Again, so everyone knows who I am. My name is Howard Davis. I'm an attorney with the law firm Meister, Seelig & Fines. I am a member of the employment group at the firm. I've been here for about 10 years, primarily practicing in the employment area with a focus on wage and hour issues. The firm has locations in New York, New Jersey, and Massachusetts, Connecticut. We have an affiliate in California, and we're actually doing some work also in Florida. At the moment, we're litigating, defending an employer in a class action lawsuit, wage and hour claims in Florida. We're actually gearing up for trials. So we practice in multiple states, but the primary focus of the talk today is on federal law, because that applies to all states and has a kind of mass appeal. Also, a lot of state laws take a lead from the federal law, though there are idiosyncrasies in state laws that that you should be attuned to, and I'll get into that. So thank you, everybody, for joining me. The name of this talk is Risks of Hiring Private. The subtitle is The Companionship Exemption is Dead. Long live the companionship exemption. So there's been a lot of talk of late about this companionship exemption. We'll start with the first slide. In the mid-70s, the federal law did not apply to domestic workers. So when I talk about federal law, I'm talking about the Fair Labor Standards Act, which is the law that provides that people have to be paid a minimum wage, that they need to be paid overtime. So domestic workers were excluded, meaning that they did not have to be paid minimum wage. They did not have to be paid overtime. And the legislature, Congress, decided this needs to be fixed, and they said domestic workers are now included. They have to be paid overtime. They have to be paid minimum wage. But there was a carve-out. They said that there is a companionship exemption, which includes home care workers. And even though most domestic workers need to be paid minimum wage and overtime, companions, home care workers do not. So that was the companionship exemption. And only recently, as you probably all know, that exemption that excluded home care workers from overtime and minimum wage requirements has gone away, sort of. So that exemption has gone away for agencies, but not for individuals. Now, that change has caused the conversation to be on the part of agencies to say, well, there's no companionship exemption anymore, so we don't have to talk about it. And for individuals, the narrative is the companionship exemption remains for individuals, so we don't have to talk about it. But that's not really the case, because just because the companionship exemption exists does not mean that it necessarily applies, and I can get into that. The final rule, which is this rule that home care workers for agencies are no longer exempt, meaning they have to be paid minimum wage, they have to be paid overtime, has special provisions for individuals. And these special provisions include that companionship work needs to account for 80% or more of the time that the companion or home care worker provides services for the individual. If more than 20% of the services provided include ADLs, IADLs, dressing, grooming, feeding, bathing, toileting, housework, managing finances, taking individuals to doctor's appointments, if that's more than 20% of the time spent, then there is no companionship exemption available to the individual. And I think that probably is the case for most. The companionship, the fellowship and protection standard under the final rule really involves chit-chatting and sharing meals and going for walks and watching TV together. Anything that's more substantive than that, more activities of daily living, instrumental activities of daily living, if it's more than 20%, then the exemption goes away for that week on a weekly basis, and overtime, minimum wage comes into play. So I think that individuals need to be aware of this fact and cannot rely on this exemption to insulate them from any exposure on wage and hour issues. Now, once the wage and hour laws apply, because the exemption goes away, there are lots of things that people need to be aware of. And just to address the first point on this slide, some individuals may say, well, even if the exemption doesn't apply, I'm not an employer. I'm just an individual. I have just one person who provides me services. I'm going to consider them to be an independent contractor. Therefore, I can 1099 them, and I don't have to worry about minimum wage and overtime and any of the other wage and hour laws that may apply to big companies. But that's not necessarily the case. I think in most cases, and there's a new DOL standard that's gone into place here, almost all individuals are being classified by the DOL and also by individual litigants as employee-employer relationship, not independent contractors. If the individual, even a person in their own home, tells the worker when to arrive to work, what to do during the day, how to do it, when to leave, how much they're going to get paid, those are all considerations that will probably establish that there's an employee-employer relationship here, and that will call into play both state and federal wage and hour laws. Before I go any further, I do want to note that this presentation is for educational purposes only. This does not constitute legal advice, and if anybody has any questions, as Adina said, my contact information is on the bottom of the page, but we're going to get into a little bit more of the legal aspect now. And I just want to make clear that this should not be considered to constitute legal advice. So now that we have established that most individuals are employers, and unless truly more than 80% or more of the time spent by the home care worker is spent doing fellowship and protection, then we're talking about a situation where federal and state law wage and hour law applies. So we have another consideration here, the joint employer consideration. Now, an individual may say, okay, I thought that they were an independent contractor, but I understand now that they're really an employee. What I'm going to do is I'm going to have an agency connect me with a home care worker, and I'll be introduced to that home care worker through the agency. I'll work a few hours with the agency, and maybe I can negotiate another rate, a cheaper rate, directly with the home care worker, and I'll do what I call a hybrid joint employer situation. So this hybrid scenario, what many individuals don't consider is that they're most likely going to be considered a joint employer. Again, there's a new DOL regulation, Department of Labor regulation, also a National Labor Relations Board interpretation and regulation that has an extremely expansive view of what a joint employer situation would be. And to explain what that is, there's not necessarily only one employer when it comes to workers. There can be two employers who are equally responsible for complying with federal and state wage and hour laws and other employment laws, employer laws. So usually when you have just an agency working with a client, even then, you're most likely the individual is going to be a joint employer because they're directing the work. But you will have, in most scenarios, the company, the agency, will take the brunt of any issues that arise. If the home care worker has any issues, they'll go after the home care agency, and if they end up going after both the home care agency and the client, the home care agency most likely will step up and defend any claims, including the claims against the individual, if really, unless the individual has done something separate and apart from what the arrangement is that the home care agency has created. But what I have seen in some of the cases where I've defended home care agencies is that we have this hybrid scenario where the individual will hire the agency for some hours and then hire that same home care worker for time separately. And what happens there is the home care agency, for example, will have hired the home care worker for 30 hours, and the individual will hire the home care worker for an additional 20 hours. So the individual then is both the employer, joint employer for the 30 hours of the home care agency, and the sole employer for the additional 20 hours work. So that's 50 hours. So that's overtime comes into play there. And that overtime is only the responsibility of the individual, the client, because the home care agency, as far as they're concerned, only 30 hours of work have been performed, and therefore there's no overtime. But the individual is creating a substantial amount of liability for himself by not considering overtime and working out of the system. So when I'm talking about wage and hour laws, the ones that most affect this industry are minimum wage and overtime. And overtime, as many of you probably know, is one and a half times the regular rate of pay. You also, another point I want to get into is the live-in situation. So live-ins are, there's some exposure there if the hours are not clearly defined when they're working. Another claim that I've seen brought against home care agencies and can similarly be brought against individuals who might not otherwise be aware of the risks are the claim that home care workers are working for 24 hours a day. I think maybe somebody is not muted. I'm hearing a lot of feedback. I don't know if people are having a difficult time hearing me. Maybe we can mute that call. So the risk for 24-hour claims is great if there's not good record keeping and there's not a clear agreement. So people may not be aware of the fact, they may rely on standards that that workers are presumed to work 8 hours if they're living in, or 13 hours if they're living in. But unless there are clear records, then the home care workers can claim that they have worked all 24 hours. Now, to require payment for all 24 hours, you don't actually have to be actively working for 24 hours, which obviously isn't possible. But there is a concept under the law called on-call, or engaged to wait. So all an employee has to do is say, well, I was never really able to leave the home. I was never able to reliably do what I wanted to do or needed to do because my employer, the individual, told me that at any point, if they call me, I need to be able to respond to them immediately. And therefore, because I was engaged to wait, even though I was watching television, even though I was reading a book, because I always had to be available at the whim of the employer, I need to be compensated for that. And there's a basis for that. Arguments against it, certainly, but that is a risk for individuals that they need to be aware of, and agencies or a well-educated individual can try to minimize that risk by having accurate records of hours worked, which can be a burden that the employer places on the worker. So that's something that agencies do, in that they require the workers to account for their hours, but individuals need to be aware of that as well. So individuals, like any other employer, have a record-keeping obligation. This is another burden that individuals may not consider when hiring privately, and may not want to put the effort in required, and it's a great risk if they don't. Records are required for hours worked in a week. Tasks completed is a good idea, because that way you can support the 80-20 companionship versus care work differential, and also the amounts paid. So often in individual situations you will have cash payments. So there's no record of the amount paid. There's no records of the amounts worked. And that not only has tax implications, but it allows the worker to make up whatever it is that they want to say they earned. They could say that they were paid $1 an hour, even though the individual paid them $100 an hour. They could say they worked 20 hours a day. Without records, courts presume that whatever the employee says is true, because the employer has a burden. Even individual has a burden to maintain records. So that's another risk for individuals who don't have the infrastructure to account for hours, to do payroll, to have the employees sign off on the hours worked. So there's a huge risk where employees are given an opportunity, and not only employees but plaintiffs' attorneys who do these things all the time and rely very heavily on this presumption under the law that whatever the employee claims is true. Of course, the employer can rebut that. They can put in evidence that what the employee is saying isn't true, but unless they have that evidence, the court just goes along with whatever the employee says, which is a big risk. And there are other considerations that individual employers, as well as agencies, have, but the agencies have the infrastructure, often workers' comp, insurance, disability, to insulate themselves and their clients from exposure and liability, where individuals may not be considering that. An employment agreement also is important if individuals were to pursue an individual relationship with a home care worker to establish rate of pay, regular rate, overtime, what hours are actually going to be worked, what hours are not going to be worked, what's on the clock, what's off the clock, and things of that nature. Now, most individuals are not all that concerned by wage and hour, because they say, well, what are we really talking about here? Is it minimum wage? I can afford minimum wage. If I didn't do it quite right, what's the worst that can happen? It's what, $5 an hour? So the numbers can get extraordinary because individuals, employees, if there was not sufficient records, can't really make any claim that they want. They can say they work 7 days a week when they really only work 2. They can say that they work 20 hours a day when they really only work 10. Without records, all of these claims are going to be presumed true, and the employer can get in a lot of trouble. I have an example here, some hypotheticals. If let's say a live-in care worker, even it doesn't even have to be actually a live-in. This could be a person who's working hourly that claims they're a live-in. Let's say they're being paid a daily rate of $100, and they claim that they actually work 24 hours a day because they were frequently, every night they were interrupted from their sleep, that at all points in time they were engaged to wait. They were told that they couldn't leave, they couldn't do the activities that they wanted to do, run their own errands, even though they spent a lot of time watching television during the day and relaxing and not actively working. They were always engaged to wait, so therefore they should be paid 24 hours a day, which is a claim that I've seen numerous times and has been successful. So this is a real concern that needs to be addressed through documentation. So this caregiver would claim that $100 was only compensation for 8 hours a day or for 13 hours a day, and that the rest of the time that they were working or engaged to wait was uncompensated, meaning that they got zero money for that time worked. So they need to not only get their regular rate of pay for that time, but when you add up all the time for the entire week, you're talking about a substantial amount of overtime. So if they're looking for $12.50, which is the amount, if you take $100 and divide by 8 hours, because that's the time they said they were supposed to be working, but in fact they worked 16 hours more, then they're actually owed twice what they should have been paid, twice more. So that's $300 a day that they're now claiming when the individual only paid them $100, and they're now entitled to overtime at $18.75 an hour for over 40, and if you do 24 hours a day, 7 days a week, you're talking about extraordinary numbers. Now, the wage and hour laws are extremely employee-friendly, and they have certain provisions where if there is a violation under the law, that as a penalty, you actually double the back pay owed under federal law. And there are state laws where you actually double it again. So if, let's say the exposure of back pay is $75,000 over the course of 3 years, under federal law, it actually becomes $150,000 because you double it. And under state law, now you're talking about over $200,000, $225,000. And on top of that, there's actually fee shifting under the law, under the federal law. So you not only have to pay your lawyer, the individual not only has to pay their lawyer to defend against this baseless, frivolous action, but in the event that any amount of money is deemed owed at the end of the case, they actually have to pay every single penny of the attorney's fees that the home care worker incurred. So the numbers can get extraordinary when you're talking about people who are effectively working minimum wage and a little bit over minimum wage jobs. I think we're just about at 9:30. I know that we started a little bit late, so if anybody has any questions, I'd be happy to address them.
Okay, I unmuted everybody, so if you have a question, now's a great opportunity.
While everybody is formulating their questions and sending them in either by chat or by being sometimes it's muted, I do want to mention that there are state law provisions that much of this conversation had to do with federal law. There are quirks of state law. For example, under federal law, there's an exemption to overtime for live-ins. But the live-in, to be technically living in under federal law, you actually have to be living in on a full-time basis or an extended period basis. So what federal law does is they say if you sleep over in 5 consecutive nights or more, then you are live-in exempt from overtime for individuals, not for agencies. Under certain states' laws, like New York, for example, which has the Domestic Workers Bill of Rights, that's no longer the case. Under the Domestic Workers Bill of Rights, you actually are entitled, the home care worker is entitled to overtime for hours worked over 44 in a week. So even though there's a federal exemption for live-ins, sleeping over 5 nights a week, consecutive nights a week, that exemption does not exist in New York. California also has a Domestic Workers Bill of Rights. Hawaii has a Domestic Workers Bill of Rights, and that law is expanding to other states across the country. So that was one other thing that I think is helpful to be aware of. Have you gotten any questions?
I don't see any questions.
Addendum.
I have a question. I know you've been actually sending us, that Stephen's actually been forwarding out to the team, about attorneys who are looking to kind of build class action lawsuits related to wage and hour cases against home care agencies. And I'm just curious if you're seeing any of that on kind of the private side. Are there attorneys that are going after kind of an individual private caregiver, homemaker, so on, to try to get at an employer?
So it's a very good question. There has been a rash of lawsuits that have been filed really over the past 2 months. I've seen maybe 5 to 10 lawsuits against agencies. That has not been happening with the same frequency with individuals. I think plaintiffs' attorneys are looking for class action lawsuits, so agencies employ many home care workers where individuals probably only employ 1 or 2. But I am currently defending a high net worth individual against a domestic worker. So it does happen. Rather than plaintiffs' attorneys that pursue these actions, there are some organizations that pursue claims on behalf of individuals, including domestic workers. There's the employment projects that exist out there. They're not-for-profit, and individual home care workers or domestic workers go to these organizations and say, I've been treated unfairly and I've been underpaid. And those organizations, on a pro bono basis, hire big law firms to defend them. So it does exist. I'm currently defending a domestic worker lawsuit against an individual right now, and it is highly contested. The amounts sought are in the hundreds of thousands of dollars against an individual, and the exposure and liability just in defending the lawsuit alone is devastating. So, people need to be aware that this is a risk, and they need to protect themselves, be it by hiring through an agency who knows the process and payroll and knows everything that is involved, or just by educating themselves and protecting themselves through agreements and record keeping.
Okay.
I have a question. What would be like the 30-second warning we could give someone who's thinking of hiring privately?
Do you want to go to the 30-minute presentation?
What?
No, I asked Mary if she didn't want to go through the 30-minute presentation.
I think I can.
Yeah,
I think I can bring. I could do about. I think I can maybe translate a minute per second or a second per minute. So I think the quick version is that the companionship exemption most likely doesn't apply to them. I think that telling them that unless they're chit-chatting all the time and that's the bulk of the work, that they're not exempt, that they have to pay minimum wage, they have to pay overtime, and that there are record-keeping obligations, and that agencies know what has to be done, and do that work for them. And without record keeping and without an exemption, they're really at the whim of the allegations of a home care worker who they may believe is their best friend and would never do anything to hurt them. But once the relationship ends, I've seen all the time people saying, I can't believe it. She was like a family member. This home care worker was like a family member. But then, they get in the ear of an attorney and it's all over. So even if they're working very little, getting paid very well, without records, without proper payment, and without an agreement and the infrastructure, courts presume that whatever the employee says is true, and they can claim anything. So there's a lot of risk there. I don't know if that's helpful. If there's anything specifically you want to use or discuss.
Yeah, no, that's good. Thank you.
I think what a lot of individuals have to recognize that maybe they don't is that they're employers, and they think of McDonald's as an employer, they think of IBM as an employer, but if you have someone in your home, there are obligations. There's FICA, there's withholding, there's tax implications and obligations. Just because you are living on your own and having only one person come into your house to do some work, they're probably not an independent contractor. You are probably an employer, and there are a lot of requirements and a lot of exposure in those situations, and a lot of potential liability.
I would also, Mary, just to throw it out there, that what I was talking about, that 80-20 rule. I mean, just at least from intakes that I've done, and anecdotally, rarely is someone looking for a private caregiver when all they want is companionship. So usually when you're at that point where you need a caregiver to come and be in the home for a certain number of hours a day or to live in, the assumption I think that we would have to go along with is that it's going to be more than that 20% of that of the caregiving, the ADLs and so on. So,
right.
But really, but that was a great question, and thank you, Howard, for giving us those tips. And really, I wanted you guys to really feel empowered with this. There's a lot of legalese here, and a lot of information, and for you to feel empowered when you're talking to not only clients but also DCMs, also discharge planners, so that they know when they're making a recommendation or they hear a family talking about something, that they can educate the families, and so everyone sort of understands all the risks. Okay, great. So I'm going to email out the presentation to everybody so you have it. And Howard, thank you very much. Really appreciate taking the time to speak with us this morning. And wishing everybody a great weekend. All right, bye everybody.
Thank you.
Bye. Bye.